Good afternoon, everyone, and welcome back to this week's episode of the Digital Law Podcast, brought to you by Digital Law and produced by Anson Evaluates. As a bit of background, we at Digital Law are a niche law firm specialising and working solely in the technology and cybersecurity law sector. In each episode, we look at recent stories in the news relating to digital technology from around the world, with a specific emphasis on data protection and cybersecurity. For more information on the stories that we are covering this week, check the links in our show notes. By way of an introduction, I'm Amelia Davies, an apprentice solicitor at Digital Law UK, and I'm joined by Peter Wright, Heather Anson, and special guest Matt Trumpets. And I will pass over to Peter to start us off and introduce our guests.
Thanks very much, Amelia. My name's Peter. I'm a solicitor and the managing director at Digital Law, and really looking forward to the special episode that we have with this week with our special guests. Who we'll pass over to. But basically, this is the, I suppose, the crossover episode that no one wanted, needed, or asked for. So we've got the Digital Law Podcast, and we're also joined by Matt Trumpets from the Missed Apex Motorsport F1 podcast. So I've occasionally been on their podcast. This is the first time we've been able to get Matt to join us on the Digital Law Podcast. So welcome, Matt.
Well, thank you very much. I'm quite excited to be here because, as you know, I have an extremely nerdy interest in legal arcana. And boy, the FIA, which we're going to talk about today, has been churning them out by the bucket load lately.
Indeed. And I know that you very often have a sort of tech theme, tech time podcasts on Missed Apex, where you're able to really go into the weeds on some of the FIA regulations, which of course is all changed with FIA governance in 2026 and the new rules there. But I'm always thinking this is almost like that on steroids today. So this is really going into the weeds on a lot of the legal and regulatory issues around the FIA. And that's another reason why we're also joined by my colleague, Dr. Heather Anson.
Hello. I'm also a person who have appeared on both podcasts.
Yes.
Yeah. So I don't think I've been on for a while, so I don't know what I did last time to warrant being not welcome back, but I'm okay with that. I'm going to try and win myself back into your good graces. I am also a regulatory wonk when it comes to the rules, and Peter will remember this from last time. Last time there was a rules change, I had it all printed out and put in a binder and had it on my lap as I was watching the races that year so that I could catch myself up on it. So I plan on doing that again for 2026. So Matt, you and I can just have our own little chat going on the side of that.
Yes.
Yeah, that'll be fun. I love that.
I mean, I think it's the funny thing, isn't it? The motorsport and Formula One in particular are one of the few sports where you can say, yes, I'll have a few LibreArch files containing all the rules at my fingertips just in case I need them. Yes. And inevitably, the activities of the stewards during the race mean that you do end up looking at those rules in a fair amount of detail. But I'll pass back to Amelia because we've got a sort of three main stories we want to look at today. So I'll pass back to Amelia to start us off.
Thanks, Peter. So in terms of the stories that we are looking at today, we are looking at the FIA cyber breach, legal action against the FIA, and the Felipe Massa litigation. But before we dive into today's stories, here's some background information on our podcast producer, Anson Evaluates. So Anson Evaluates are a consultancy company offering a variety of services, including data protection training, outsourced data protection officer services, and specializing clients over multiple jurisdictions. So starting with the FIA cyber breach. This is quite an interesting one because it's been labelled as a cyber breach, but is it really a breach? And I would just start with that kind of broad kind of question there. Heather, did you want to dive on that?
Well, it's not a question. It's more of a statement because this comes up so much because both Peter and I do a lot of data protection work, and being the managing director of Anson Evaluate, gee, I wonder where it got its name. This idea of, is it a breach? And I think because the term is used quite differently than the normal use of it in everyday life, that people get it wrong, including lawyers and law firms who don't specialize in data and data breaches. So is it a breach? It absolutely is. under the law.
Shall we
Because
explain what happened
oh yeah,
first?
you do that first, and then I'll tell you why it's a breach. How's that?
That was my next question. So what's happened, Peter? You seem quite keen to go through this.
Yeah. So the FIA, the Fédération Internationale d'Automobile, the regulator for Formula One and world motorsport, controls, as you can imagine, an awful lot of personal data. Drivers, data related to accidents, circuits, events, member bodies, because basically everyone from the you've got everyone from like the Royal Automobile Club to the Automobile Association to loads of different automobile associations around the world, all are members of the FIA. So a huge amount of data washing around that organization. On their website, they have a portal that allows all of the super license holders, i.e. those who have a license to be able to drive in Formula One, the top tier of motorsport. There was a portal on there that was hacked by what's known as a white hat hacker, who basically accessed the portal and accessed the passport of reigning world champion Max Verstappen. That portal ended up having accessed that. They then said, look, we've got this, and they shared that information with the FIA. Now, I'm going to pass over to Matt at this point, because, Matt, you covered this same story on Missed Apex last week, which was the reason why we wanted to invite you on.
Yeah, so this is an interesting one. As you mentioned, the FIA actually covers rather a lot of ground as a nonprofit. It has multiple overlapping areas. And in this case, the access that was gained by Ian Carroll, who was the hacker, the white hat hacker, who found the vulnerability and informed the FIA of it, was intended mainly for sports car drivers who were classified platinum, gold, silver, and bronze. But this same access is used by a lot of super license holders, including Max Verstappen, who famously competed at Nürburgring, Nordschleife, not too long ago. So they access it in order to maintain and update their licenses, as well as to receive decisions about upgrades and downgrades and stuff like that. It's all very normal for anyone who's ever done anything online. But what the hacker discovered was he could gain administrative access, and that allowed him to see all of the records of all of the drivers. Now, with regards to Verstappen, I don't believe he actually looked at the passport. I believe they got to the point where they realized they could access the passport, did not do that, but sent this evidence to the FIA to inform them of the issue. Now, I'm already kind of interested, because if you'd asked me ahead of time, I would have said that even the singular access technically constitutes a breach because someone had access to data they weren't supposed to. But where I start to get very curious, and I'm sure everybody else will be too, is, well, if it was possible to do for this, I mean, I've uploaded credentials to the FIA before when I went to cover Formula E races as a journalist. Well, if it's possible in this particular case, in this particular portal for drivers, how protected are their other portals? I came across preparing for this the form to apply to run for the president of the FIA, and I had this sudden thought, I wonder if I could get away with exactly what this hacker got away with. So I think this also brings into question sort of a larger issue for me as a motorsports person, not a law person. What is the FIA supposed to have done to protect this data? And the fact that they failed to do it, is that potentially problematic for them with regards to fines or things like that?
Peter, Heather, before you dive into kind of going back on Matt's point there, do you want to just explain what a white hat hacker is? Because for our listeners, they might not quite understand this. Heather, you seem eager to answer this.
Yeah.
I literally wrote it down. I literally wrote it down. Explain white hat hacker. Sorry about that. That was a dog tripping over a cable. Very clumsy. Anyway, I realized why I haven't been invited back on both podcasts. I tend to jump the gun and over talk things, so I apologize, and I'll try not to do that again. We'll start with what you asked, the white hat hacker. White hat hackers are, we know from the Old West terminology of if you wear a white hat, cowboy hat, you're the good guy. It's a movie trope. You know, the black hat is the black guys. The black hat is the bad guys. The white hat is the good guys. We won't go into how that is a bit racially incorrect, but anyway, a white hat hacker means they are good guys. They try and hack systems for good causes and good reasons. And you think, okay, well, what's in it for them? Well, some of them are just kind of odd, like Matt and I, and like what they do so much, and like we like regs to read them. They like to just try and hack into different things. They find that, decent exercise. However, there are people out there who make money on this because a lot of the big tech entities like Google, Facebook, Meta, all of those will actually pay. If a white hat hacker finds a vulnerability, they contact those organizations through a source that they've put up for these white hat hackers. And if it turns out that is a verifiable vulnerability and that they can fix, then that person will get paid. So white hat hackers can actually make a living doing that, hacking into things. So I hope that explains the white hat hacker thing. Now, breach. So as Matt said, yes, the person being able to access that system in a way that and access those licenses in and of itself is a breach. And not just because he breached their system, but that's the term that we all think of. He breached the system, therefore it's a breach. Under data protection laws, both in the UK and in Europe, the term breach, a data protection breach, applies to a breach of the data controller's obligations under the Data Protection Act. So the fact that the person got into the system itself is not the breach. The fact that the system was not substantial enough to withhold that meant that was a breach of their obligation under the Data Protection Act. They are required, given their size, to have a reasonable amount of protection. It's a scale. So if you're a tiny business and you get breached, if you get hacked, they will have a different attitude towards you versus if you're the FIA and you have a lot more resources. So considering the size and the amount of data they have, it shows that they did not have the appropriate controls in place.
Matt, did you want to come in on that?
I did indeed. And so here's an interesting thing. In looking at this information, one thing that I went looking for on the FIA website was their data policies. And they actually have two separate ones. One for their administrative and non-motorsports people, and then a separate one for the motorsports thing, which raises its own question of why would you need two? But I suppose it's possible because they have a separate level of information they require, including medical information from the driver. So potentially there's an explanation for that. But they list specifically the regulation under which they operate. As far as the GDPR, if I'm remembering those letters in order correctly.
Yeah.
Yes.
And me being me, I actually went and read through it, skimmed through it, and I found the following, which was Article 39. Personal data should be processed in a manner that ensures appropriate security and confidentiality of the personal data, including for preventing unauthorized access to or use of personal data and the equipment used for the processing. In other words, by their own standards, they have failed here.
Yep.
And I have a follow-up question, which is, you mentioned the FIA in terms of size, but if I'm looking at the FIA, if I was looking at any firm, how do I determine size? Is it the amount of money, the revenue? Is it the amount of employees? Is it a combination of the both?
It's the resources available and the level of sensitivity. In fact, you mentioned medical information, which means that if there is medical information being kept, they are in a separate category, which is called sensitive special category data, which includes medical information. That's particularly sensitive data that requires an even additional, an even additional amount of care and control. So that is when they have medical information, they have to go above and beyond. So when you say what's reasonable, yeah, you've got the resources of the company, which means how much financial information, financial resources they have available, how much information they're holding on what people, and then the third bit being how sensitive is the data that's being held. So if medical or other special category data is being held, they have a much higher standard.
You've mentioned that there's kind of two privacy policies. Peter, I think you had a point that you wanted to mention on us around transparency.
Yeah, so it's a good point that you make, Matt, that it might make sense to the FIA in terms of, well, we've got this policy for this type of data and that policy for that type of data. And there are organizations that try and do this. They'll say, for example, oh, we have one privacy policy on our website that governs data related to the users that go on that website, but they might have a separate privacy policy that governs then data that they collect during the course of selling their goods to customers. They might even have a third privacy policy that then dictates how they handle the personal data of their employees. So you do get some organizations that say, well, we've got different policies for different types. The problem with that approach is that the general approach of the legislation is it tries to say it should be clear and transparent to the data subject how their personal data is being handled. And if you've got three different policies potentially squirreled away in different places, so you might have a HR one on a HR portal, you might have the website one on a website, you might have another portal that people are using to then buy whatever it is, goods and services. So you could have three different policies. It might not be obvious to the data subject, the individual whose personal data it is, well, where do I find out how my data is being controlled? And if you've got that level of ambiguity, that's already, if you then are trying to explain that to a regulator in the event that something's gone wrong and there has been a breach, guess what? You're already in trouble. So arguably by the approach that the FIA is taking here, it might have made perfect sense to, I'm sure, an internal committee of the FIA that looks at rules around internal governance and how these things should or should not be done. And I'm sure there's been a room of people wearing business attire who've all thought very carefully about this and decided that's what we're going to do. But it's not necessarily going to work in or be a transparent, navigable way of handling data for the data subject. And that's the most important thing. It's not what works for the organization, it's what works for the data subject.
It's interesting to mention here as well the fact that the FIA is based in kind of two different jurisdictions. You've got France and then you've got Switzerland. Does anyone want to make a comment on that?
Well, it's a point well made. And actually, Matt, we were talking about this, weren't we? That so the FIA was moved. I think it was back in the Max Mosley days that they decided to move from Place de la Concorde to Lausanne, the place where regulators go to die, seemingly. So they just sort of went to Switzerland and they were all, set up there thinking, this will mean that we can escape the rules and regulations of the European Union, which in the late 90s was starting to add more and more regulation by way of its directives. Since then, it's only increased. You then get the regulations like GDPR, which you mentioned earlier, Matt. Now, the interesting thing is that you might think, well, we're in Switzerland, we're outside the European Union, this isn't a problem. Well, unfortunately, it's not that straightforward. While Switzerland isn't a part of the European Union single market, it is part of the European Free Trade Association, along with Norway, Iceland, and Liechtenstein. And while it isn't in the European Economic Area, which those three other countries are, along with the 26 EU member states, I think it's 26 after the UK left. I always lose count. But the point is that Switzerland, rather than being in a formal structure, instead it has a huge number of bilateral treaties with the European Union saying, well, we'll adhere to your rules on agriculture under this treaty, and we'll adhere to your rules on banking with this treaty in a certain way. So there's this slight element of variation. So it's like we follow a lot of European rules, but we're not in the European Union and we're not in any formal mechanism to allow it. So in terms of data protection law, we've therefore got a Swiss federal data protection law, and that came in 2020. It has a lot of bits of GDPR in there, but it doesn't echo it perfectly. But a lot of the obligations that we will be interested in this instance still continue to apply through that Swiss data protection law.
Okay, so now I'm going to ask yet another question because I don't often have access to fancy high-priced lawyers who will answer my questions for free. With regards to jurisdiction, I'm just thinking of Americans who've famously been sued for libel or defamation in UK. Here, your victim, the only named person, Max Verstappen's records, is a citizen very much of the EU. So how, in the event of a data incident like this, or a data breach, we'll call it by its accurate and technical name, is that not determined by where the victim is located rather than by where the company is located?
Very good question. There is, and we'll go into it later with, I think, one of our other topics, but choice of jurisdiction is generally around where the person lives and that. But under GDPR, there's something called one-stop shop. So if they were because they have chosen CNIL, the French regulator, to be their regulator in Europe, that means that regulator, so it wouldn't go to court on that in that instance. So it would be the regulator looking at it. So we're not looking at it jurisdiction of which court it would go to. That means that the regulators in each one might investigate it, but if the data subjects who are on that, and to be fair, not just Max Verstappen would have an issue. Anyone who had information on that portal who then realized their data was not secure could have an action claim on that. And that's where things would get very complicated in terms of choice of law and jurisdiction. I don't believe there is a substantial case law on this yet, but there is something in a term in law called long arm statutes, which means that how far outside of where the law is can you reach? So can like if they're saying, oh, this is Swiss regulator, this is under Swiss law, not French law, but a French individual's data is at issue, or in this case, Max Verstappen, if his is an issue, he's a EU citizen, then they would say we have the ability under GDPR to reach outside of the EU to go after that company. And there has been precedent for that. A Canadian company a while back was actually fined by a regulator. It was actually the UK regulator, I believe.
It was. I think it's IQ.
Was actually fined by the regulator here, even though they weren't in this country. They had violated data protection of citizens of this country. So the regulator was able to reach outside with a long arm, was able to reach outside of the jurisdiction to find somebody outside of it. And I imagine that would be the case here too. If they, as a regulator, could reach out and take FAA where they are.
The interesting thing with that, though, is that because we have two privacy policies, guess what? They refer to, well, for certain things we'd be responsible to CNIL, the French data protection regulator, and funnily enough, so you've got a separate data protection regulator in each EU member state.
Yeah.
And guess what? Some of them regulate and enforce the law in different ways. And surprise, surprise, the French data protection regulator tends to have a more strict reputation compared to some of the more laissez-faire regulators. And So they've tried to say, look, for certain things we're regulated by CNIL, and for certain things we're regulated by the Swiss data protection regulators. And
But do they get to choose?
well, and this is just it. I think it is, again, you're coming into the realms of it almost being deliberately ambiguous. And again, that makes it difficult for data subjects.
Mhm.
But in this instance, if you are Mr. M. Verstappen, then you would be sort of thinking, well, in this case, I'm going to be speaking to the EU regulator to see what they're going to do in relation to my data. So I can imagine a lot of those who might be concerned about the practices of the FIA in the light of this incident may therefore be contacting CNIL to say, well, what are we going to do now?
Okay.
So this is an interesting thing that I have noted before about the EU, and particularly the regulations. You mentioned Max, or potentially at this point, any driver could reach out and say, I see that my data has potentially been exposed, and make a complaint to the regulator.
But
But as
also
far as
they can make it, they can actually under GDPR they can actually file a civil case if they can prove that there was some harm to them because of this.
right, so in the absence of anyone complaining about it, is there any risk to the FIA as far as fines go? So you'd have to demonstrate not just that it was potentially exposed, but there was some actual harm that resulted, which is which seems pretty normal, at least from over on this side of the harm. You this side of the pond. Usually, like if your data escapes to the wild and winds up on some list, they send you a check for $5 and say, "Oops, sorry, we promise we won't do that again until the next 6 months elapses."
Well,
But yeah,
sorry, generally you don't have to have a data subject make a complaint to the regulator for the
No.
regulator
okay,
to investigate.
that's what I was really curious about.
Yeah, they will investigate on their own because they will say this is our obligation. It's not like civil lawsuits where there has to be somebody bringing with the harm, bringing the action. That's their jobs. That's the regulator's job to investigate and fine, so they can do it absent.
And guess what? Some regulators are more proactive on doing that sort of thing.
Is France one of those? France one of those?
Take a wild guess.
I think they are. Yes.
Yeah.
That brings me nicely on to kind of my next question is, what does this mean for the FIA? You know, what does this breach mean? Because we are conscious that it was a white hat hacker. Try saying that 10 times in a row. It was a white hat hacker that caused the breach. But what does this mean for the future of the FIA?
I think that depends on how the FIA responds to this, because much like Nixon, it ain't the crime, it's the cover up. So a lot of regulators will say, okay, you found out that this happened. What are you doing to mitigate it? If the FIA absolutely plays ball and says, okay, yeah, we're doing it. We found this, we do it. If they're very proactive, the FIA, which, gosh, not sure if that's their reputation, but if they are proactive, then the regulators generally will be, they're like, okay, yeah, maybe you didn't have the ability to figure this out before, and now you figured it out. You're taking something, doing something about it. However, if they do what I think they're going to do, and they stonewall, they try and argue the toss or anything like that, that's when they will have a larger investigation.
I think
probably
we can bring Matt in on this, because I think certainly what the published press appears to be saying, that upon notifying the FIA, they actually took it pretty seriously.
Yeah, I'm not surprised by that. I think the issue with the FIA is rarely intent. It's just honestly, it's basic competence. A lot of people don't understand that the split between the commercial and the regulatory regime, which happened back in 2000, maybe 2001. The deal was finally done between Mosley and the EU. Also took all of the revenue, commercial revenue from Formula One, and set a price and leased it to not the FIA. It was one of Bernie Ecclestone's companies at the time that is generally referred to in the press as FOM, but it's actually a lot more complicated than that. And it's been through several changes of ownership. And there's actually some interesting questions about that, as the current owners of F1 have bought into MotoGP, but the current owners of MotoGP were required to ditch their F1 interest back in the early 2000s when they acquired MotoGP. So that's like a whole nother topic for a whole nother day for you.
Yeah.
But what has happened with the change of administration from Jean Todt to Mohammed bin Sulayem is there has been a lot of, and I'm going to phrase this politely, administrative churn.
Yes.
And a lot of changes with regards to, I would just simply say, the user experience of the website. It's been redesigned multiple times. Stuff is no longer now where you used to be able to find it 5 or 10 years ago. And it wouldn't surprise me at all with all the renovations that something like this was literally just a hangover from the way things were done 10 years ago. So them saying they take it seriously is one thing, but them actually upgrading all of these access points in a way that prevents this sort of unauthorized joyriding, let's say, since we're on a motorsports themed podcast here, is a separate thing. So the question is, what do they have to show to the regulator to say here, or I mean, again, like I'm reading through the possibilities, they could even say, well, we actually had a third-party vendor do this, and we are going to blame them for not being more thorough about it rather than it's being done in-house. But what are they going to have to show to the regulator to have their response treated as a mitigating factor in terms of whether or not they get a fine for this, and if they do get a fine, the size of that fine?
Heather, before you come in on that, do you want to just speak about something that Matt brought up there about third-party vendors?
Yes, that's actually what I was going to talk about.
There we go.
Third-party vendors in the data protection world, also called processors or sub-processors. So if anyone was handling this and handling data on behalf of them, they have some responsibility, but the data controller ultimately has responsibility. So if they weren't properly monitoring it, they didn't give clear enough instructions, there was a fine a while back, even pre-GDPR here. So this is goes back a while, where data controllers are responsible even if data processors screw up, if they've not done their job in supervising it. So if the FIA, that won't help the FIA if they say, oh, we had a processor or sub-processor handle this and they screwed up. Well, then the regulator is going to say, well, how clear were your instructions to that processor? How was your supervision of that processor? Did you audit what they did? How much did you actually look after that process? So pushing it off on a third party, in this case, a processor, is another way to annoy a regulator. So they couldn't reasonably have predicted this breach. That once they were made aware of the breach, that they have been taking proactive steps in order to make sure that breach does not happen, that they've notified everyone of the breach who has information on that particular site. That basically, the more proactive they are, the better. And the more, if they're able to prove that they couldn't have reasonably foreseen this, the better. So it's going to be those two factors. If they really weren't paying attention and they should have, they might get in trouble for that, but that could be mitigated by them now taking it seriously. So that's the two sides of it.
Does anyone else have anything to add before we sort of round off the discussion on this first FIA story? No.
The only thing I would add is it's always important to remember the FIA is a very poor cousin relative to Formula One.
Yeah.
Because of the agreement, essentially the amount of money, I discovered reading the actual agreement, the amount of money wasn't set by the FIA in terms of the lease of commercial rights. It was set by the EU, and it winds up being a very paltry sum and generally speaking, not nearly enough to really run their side of the regulations as you would expect them to be, given the total amount of money that Formula One is now worth.
Yeah.
But at the same time, you've also had recent leadership that has increased the probability of this sort of thing happening by churning through lots of personnel.
Mm-hmm.
Lots of people have left or been fired, and by instituting large changes at the same time. And I think some of the other stuff we're going to talk about is going to come more onto that. But I'm not surprised this happened. Very curious to find out if they wind up having to pay for it. And I mean, honestly, I'm thinking now, like 10 years ago, 15 years ago, I used to find things on the FIA site just by changing the end of the web address that it wasn't necessarily hidden, but you couldn't also find on their menus at all. I realized that they had detailed certain races certain ways, and I could go find documents from those races that I couldn't access through their standard menu. So, yeah,
Non-searchable pages.
not a real big surprise to me, honestly.
Yeah. And we shouldn't expect anything from either the Swiss or the French regulators anytime soon, because they do move rather slowly. So it would be surprising to hear anything from them for a little while.
And I think, I mean, we'll be going on in our next bit. We're going to be looking more at the FIA and its governance. But I think this story as a whole is problematic for the FIA, given the sort of steady drip, 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 which we've hinted at a little bit over the last few years, to the point that we know, I think, certainly the owners now of the commercial rights to Formula One, if they could find a different regulator rather than the FIA, I think they'd probably be quite happy to do that. But of course, there's the practicalities of, well, who else could you possibly get that has experience in running world motorsport? Well, there isn't anyone. So it's kind of, they're sort of stuck with each other.
I could try.
But this has certainly been, you occasionally, I think, get grumbles from Liberty Media, who now run Formula One, who are, throwing of hands in the air saying, well, this just isn't good enough. And I think that's just it. Perhaps in America, you would be thinking, well, let's do this differently. But unfortunately, it's the legacy is you're sort of stuck with the FIA. This is a story like this, as I say, just add that to that drip, drip, drip of overall dissatisfaction. And as you said, Matt, that fundamental lack of confidence and lack of grip. If you can't do the basics, if you can't even look after the personal data of the world champion, well, how can we then have any confidence in the broader administration of the sport, your decision-making processes, and the other regulatory principles upon which everything else is supposed to stand, particularly in the fact that we have a brand new set of regulations next year. Loads of issues will come up in terms of questioning those regulations, and it takes away people's confidence overall with that administration.
I'm just thinking, if Papa Stroll wants to put together another large venture capital project, it could be, getting a bunch of very wealthy sporting enthusiasts together to create another regulator to compete. There you go.
Well, once his team has won the World Championship, maybe that'll be his next project.
There you go.
Anyway, you can move us on now, Amelia.
Yeah, I will move us on to the next story. So we are now looking at the legal action against the FIA, and this is by Laura Villas. So essentially, in terms of background, there have sort of been persistent issues raised in the past few years around FIA governance. And I know that this has already been mentioned in this podcast so far. This is a fairly interesting story because we're currently looking at candidate elections. Peter, do you want to fill us in on a bit more of the background on this?
Well, actually, I'm going to actually say, Matt, would you like to take us through on this one? Because it's an interesting story. It has, again, it's sort of got tendrils going back into the past in terms of how previous FIA presidential elections have been handled and some of the governance issues that have come into play in the current election, which let's put it this way. I think there have been a number of candidates who've expressed a willingness to try and unseat the existing president of the FIA. And then the fact that they've not been successful in getting on the ballot has then led to the litigation that's now taking place.
Yeah. Okay. So this is actually a long-standing beef of mine with the way the entire sport is run, which is the FIA president, when they run, also determines sort of the benefits all the member clubs get. And there are a lot of member clubs that have almost no money at all. And just the way it's structured, it's not just a straight up, you declare your candidacy and WMSC, which is made up of all the worldwide automobile clubs, vote, and whoever gets the most votes or a plurality wins, or or they go to a second or a third ballot till you have someone with a majority. No, no, no. Here's how it works, and you have to have a list. The list has to include all these different offices, including the president. And on that list, you have to have a very specific combination of people from around the world. Now, this seems to make sense. It's a worldwide thing, but I'll run it through. You need you need vice presidents from sport, 2 from the EU, 1 from North America, 1 from South America, 1 from Asia Pacific, 1 from Middle East, North Africa, and 1 from Africa on your list in order to be a candidate now.
Hmm.
You can say you want to run. And we had Carlos Sainz Sr. say he was going to run. We had Michael Meyer say he was going to run. We had Laura Villers, and we also had Eugenie Philippot, I think, say. So we had multiple candidates saying they intended to. And here's the thing. When you get to South America, there is only one vice president in that region, which means effectively you can only have one candidate for president, which means effectively all you really have to do is have that candidate on your side, and then you have no legitimate competitors according to the rules as they are currently written. And interestingly, the candidate, the VP from South America, is Fabiana Eccleston.
Yes.
Fun fact that. And she has already been added to the list of the current FIA president. Now, there's been, as you mentioned, a lot of dissatisfaction. And really, a lot of this goes back to Motorsport UK, which is the UK automobile club that's in the WMSC. And they've been making ethics complaints because the ethics rules have changed. Who determines ethics violations has changed. And it's all concentrated more power in the office of the president. But what's also changed is during COVID, they allowed themselves to have online meetings instead of in-person meetings. And increasingly, these votes where these rules are being changed are happening online and not in person. Complaints have been made about that as well. And to my understanding, this is sort of your deep context background, have not been answered in a way that is really considered by responsive by the people who've made these complaints. This has been piling up over the last year and a half. And so now we get to the election time. And as I said, there have been various candidates who put themselves forward and then dropped out, seeing the impossibility of it's happening. But the candidate, Laura Villers, has actually filed a court action in Paris asking for what I would call a temporary restraining order or an injunction on the election happening until the court can hear her complaint in full. And there's a conciliation meeting that's supposed to happen first. And I have a statement from the lawyer that says, we have obtained authorization to file an emergency subpoena. This shows that the judiciary is taking serious democratic deficiencies within the FIA, which, you'd have to say it's hard to call it a democracy if one person gets to decide who wins.
Yeah.
As well as the various violations of the statutes and regulations we are reporting. This procedure aims to ensure that FIA's upcoming presidential election, currently set for 12 December, complies with the organization's own statutes and with fundamental democratic principles. So it's pretty easy to see, from my point of view, where they're going. They also reference Statute 1.3 of the FIA statutes, which says the FIA shall respect the highest standards of governance, transparency, and democracy, including anti-corruption functions and procedures. So We'll see what comes out if they indeed keep the election from happening and go to trial. But Motorsport UK has threatened lawsuits over the ethics and changes in the rules for quite some time, and it seems like Villers is the person to finally put the rubber on the road, so to speak.
Yes. So indeed, in Motorsport UK got rather, I think, and Matt, you'll be able to correct me on this, because I think it may have been, was it World Motorsport Council meetings that they tried to basically insist that everyone who attended would have to sign a non-disclosure agreement.
An updated non-disclosure agreement
Yes.
that essentially would not allow them to complain about stuff to the press.
Exactly, which meant that, and they said, look, in the interests of good governance and transparency, that goes against the most basic tenets of good corporate governance, certainly under UK law and arguably under EU law. And from that perspective, Dave Richards and Motorsport UK said, well, we're not signing that. To which then I think the FIA said, well, we'll bully you until you do it, which again didn't go down very well. So I use the word bully there in the broadest possible sense, but basically it's symptomatic of the stories that have persistently been coming out within the specialist motorsport press with regards to how the FIA has been handling its internal governance and its relations with those member motorsport associations. And then it looks like, as you say, this is now the first time that we'll potentially have an independent judiciary shining a light on the working practices of the FIA and actually saying, well, actually, is this working in the way it's all intended to? If, and this is where it'll be interesting when they get through to like the first time it actually gets before a judge and they start saying, I think, if they actually consider it, because I'm sure the FIA will then turn around and run an argument saying, well, this has nothing to do with the courts in France.
You do have the jurisdictional aspect of is Paris the appropriate place, but they are headquartered there, and if you sort of look at how they bust out, they have their own chart. I mean, I think you have a reasonable argument that Paris is correct, but if it's not correct, Switzerland would be the other place. And here, I do think it's a fun fact that Villers is a Swiss citizen, and she's a driver. So I feel like from a jurisdictional point of view, you've got that covered off. But for me, what I would like to know from someone who knows more about the continent, and certainly French judicial practice is far different. Like if this was in the U.S., I would say this is a civil lawsuit. You'd be getting a preliminary injunction, and there will be discovery, meaning that if I'm Villers, I can ask for records from the FIA communications and in time periods and from people that will be introduced into trial as evidence for the person doing the deciding, a jury or a judge. Is it similar, or is it or is the process more, if the judge takes the case, then they will direct essentially an investigation themselves?
It would be more it's slightly different with regards to the fact that France, the judicial system is slightly different to what, for example, I'd be used to here in the UK. But generally,
you're closer geographically, so I'm just assuming that means you know more about it.
Yeah, but this is just it. Actually, a lot of the US law system is more based on the common law approach that we have in the UK, as opposed to the more Napoleonic code-based system in France. But overall, when it comes to contentious litigation of this type, yes, you would then have the court making directions with regards to discovery and what does or does not need to be disclosed in order to satisfy evidential requirements before you can then get to a hearing. And if you're going to have a full-scale hearing, then sometimes some quite tight deadlines are set down. Of course, in this instance, it will be, well, are we going to grant the injunction first before we then have a more protracted legal process to follow that would then actually allow that election to take place after the injunction's been enforced to prevent it happening in December. Now, what's interesting here, of course, is that the basis of the claim seemingly that Villers is making is saying, I've been in protracted discussions with the FIA in good faith. I've received, here are all the emails and communications I've had, which I have relied on in good faith, yet to my detriment, in that I've then not been able to actually take part in this process. And it will be interesting to see. And I don't think she'd have taken this step and wouldn't even be considering going to court and taking this step if she didn't have fairly convincing evidence in black and white in those emails to back up the essential thrust of her claim. Now, the court will then probably say, well, we'd like to have more records and references here to other process, what was said within the FIA before they then clicked send on the email to Villas, where they were answering her various questions or not, as the case may be. But the point, and that would be interesting in of itself, just to get disclosure of that. But I suspect that she's got quite a bit already in black and white. Otherwise, you wouldn't be even contemplating this step due to the expense involved and also the cost implications of paying the other side's costs if you get it wrong.
So that is a risk for her bringing the case in France. Okay. I would immediately think of a large line of very disaffected employees who've walked out of the door over the last 2 years as being as being a potential source of some of this information. And I'm just curious. Again, I don't know French law, but having read through the FIA rules, I don't see how it's defensible in the slightest that this is a quote unquote democratic process if you can only have one candidate. I mean, that just strikes me as is immediately kind of a win for the plaintiff here.
Exactly, because the way that this has ended up just looks incredibly fishy, and it does look like there is a significant democratic deficit if you can't have an open, fair election. So that's where this is going to potentially get very interesting very quickly.
Yeah, and as I said earlier, the other thing that we didn't really discuss, and this is more of a general impression from the motorsports press than something I've gone through and confirmed myself, but the flows of money to the automobile clubs is controlled by the president's office, who then ultimately needs a majority of them to support him. So it's interesting to see where that money goes when there's an election. And then who winds up supporting the president?
Yeah.
As a result, you can sort of look at some dots and draw some lines, and you see what you see. But what's the fix here? What happens? What happens if they do indeed find that it's not democratic, that the ethics, that all of the rules changes were illegally done, which I think is going to be ultimately the claim, going back through the various changes all the way to the NDA.
Yeah.
Because of the way they were voted on, they weren't valid according to FIA's own statutes. If the judge finds fully for this, what is there a remedy? What happens at that point is the other really open question, and I don't have any insight on that because I have absolutely no familiarity with French judicial decisions.
And indeed, and this is where we have certain limitations as well. So, I'm a solicitor of the Supreme Court of England and Wales. In terms of remedies, this is where it could get very interesting, because obviously initially we're looking at an injunction to try and delay the election. What sort of impact would then take place to an election that's been delayed? You then, I'm sure, will get the FIA pushing back, making various arguments with regards to, well, does that have jurisdiction or not? Though interestingly, of course, it was actually a French court that said that Flavio Briatore could come back into Formula One, and they adhered to that. Even though at that point the FIA had said that he wasn't allowed in. So in that instance, a judgment of a French court was found to be perfectly acceptable. And that also gives us an interesting indication with regards to the jurisdiction argument again. But how much interference could you potentially have from the French court in the operation of that election? That's going to be the interesting point. There's also the question in terms of, well, how much involvement does the French court actually want to have in that process? So does it want to then potentially think, hang on, by taking too many steps, we've actually interfered with the way that this has taken place, and we don't want to be potentially interfering every time there is an FIA presidential election. So that's where it's going to have to be handled quite carefully and sensitively as well. So I think to a certain extent, we're going to have to say, watch this space.
That brings us kind of nicely to the end of that story. So moving on to our last discussion of the episode, we're looking at the Felipe Massa litigation. So just in terms of some background on this, a high court claim by the former Formula One driver Felipe Massa for £64 million in compensation for the infamous 2008 Crashgate controversy has begun in London. So lawyers for Formula One, its former chief executive Bernie Ecclestone, and the sports governing body, the FIA, attempted to get Massa's lawsuit thrown out on the opening day of proceedings. So did we want to unpack this? First, I'll pass over to Matt.
Oh, of course we want to unpack this. This is one of the most widely recognized and discussed episodes in Formula One history with regards to intentional cheating for a lot of different reasons, but ultimately because many people associate the events of that day, evening, day, morning. I guess it depends on where you were watching. With the eventual conclusion of that year's World Drivers' Championship, which saw Lewis Hamilton in the last quarter of the last lap of the last race, beating Felipe Massa by a single point to the championship. And that's been a loss that Massa has taken very hard. But many people will point to the events of Singapore as the reason why that occurred. I think that is erroneous and incorrect analysis of the data. However, it's something that is simply out there as a narrative. So, to wit, Renault, where Fernando Alonso had moved and was run by Briatore, formerly of Benetton, also known for their squeaky clean participation in the sport.
Allegedly.
Oh, you have no idea the amount of research I have done for you for this.
Yeah.
And what happened in essence is they ordered their other driver, Nelson Piquet Jr., to intentionally crash on lap 12 so as to advantage Fernando Alonso, as they've been really unable to score points or even a victory. And this plan worked out very well. It worked exactly as intended. Brought out the safety car. Alonso had pitted right before it happened. He was able to get to the front, and because at the time there was also refueling, the way they figured it out, he was able to win the race as a direct result of Piquet's crash. A secondary result of Piquet's crash was a lot of other drivers making pit stops, trying to take advantage of the safety car that was brought out while Piquet's car was cleared. One of these drivers was, in fact, Felipe Massa, who inadvertently drove off with the fuel hose still attached to his car, caused a huge fire, and had to retire from the race, scoring 0 points, where I believe at the time of the incident, he was either leading or he was in the top 5. So his claim all rests on the fact that had this crash not occurred, he would have scored points and would therefore have been the world champion. And furthermore goes on, and this is where it gets really interesting. The court case didn't come about then. It was disclosed later after the award ceremony that Piquet had in fact intentionally crashed. And that came about when he was let go from the Renault team. Suddenly he was willing to tell everyone what happened, and there was an investigation, and that's when Briatore got banned, Sims got banned for a long time. Alonso was held blameless, even though there was lots of people who felt it couldn't have really worked without him being in on it, because the pit stop was very oddly timed for your usual Singapore strategy. But there was never definitive proof of that. And then in 2023, Bernie Ecclestone is being interviewed on German TV and says something to the effect of, oh, yeah, well, we all actually knew about that and the race should have been canceled, but nobody wanted to make a fuss because Lewis won the championship. And the next thing you know, Mass has gone to lawyers, and here we are now.
Yeah, exactly. And I think the interesting thrust on all of this, and this is where I think any claim is going to succeed or fail, is on the fact that we are sat talking about this and it's now 2025, yet all of this happened in 2008. Crashgate itself, as you hinted at there, Matt, that was so after the 2008 World Championship concludes, that doesn't come out till the middle of the following year, 2009, when Nelson Piquet Jr. was let go. And he then says, well, hang on, I went and had this crash. I did this specifically, and this is your loyalty. I went and did that thinking you'd keep me on, and now you've gone back on your word. So if you're going to go back on your word, I'm going to go back on mine. This is what I was asked to do. And hence where Flavio Briatore gets his reputation from. And that's therefore the fact that, that we're more than 15 years later now. And this claim is being brought in the High Court in London. So the jurisdiction is the courts of England and Wales. And in England and Wales, we have a limitation act that says that if you are going to bring litigation, it has to happen within 6 years of the issue that you are identifying having taken place. If you're going to have it happen outside of those 6 years, you have to have a very good reason why litigation couldn't have occurred within the 6 years that you've been allotted under that statutory limitation period.
I was going to say, for our American listeners, we call that a statute of limitations, which I think is a more appropriate term, because if you miss the SOL, you're SOL.
I like that. That's an easy way to remember. Now, I would ask you then, if we are to take the interview as evidence, that what he said at the time is evidence, ignoring the fact that he has since said it was a poor translation by it was a poor transcription or translation by someone who wasn't an English speaker natively.
Yeah.
And ignore the fact that he's been known to say all sorts of inflammatory stuff for absolutely no reason whatsoever. And so if we ignore those two things and say, no, we will take this as actual being the truth. He said it, and that actually effectively describes the situation as it was prior to that awards banquet. Because the other side of the awards banquet, the statute of the FIA says they can't change the result. So doesn't matter. We can say it happened, but you're not getting a world championship. And I think he's suing for money in terms of damages to his career because he didn't get it, but should have. That's sort of his thing. Would that qualify then as the kind of evidence that would let you bring a claim this late under UK law?
Well, I think the issue with that is that it depends on how the court perceives that interview and what was said after it, because generally the statutes are you have a certain amount of time to bring the claim from either the time it occurred or when it was reasonable that you knew something had happened. Or what we say in the US, whether it was known or should have known, if you knew or should have known at that time. So the argument that you'd be making in Massa's point would be that this guy has he clearly walked it back. He was annoyed, and so you can't take it seriously. Plus, it would be inadmissible in court because it's hearsay, which for our legal audience, I hope I don't make you twitch because this will remind you of the bar exam. Hearsay is an out-of-court statement repeated in court to prove the truth of the matter stated. So what he said, if you said in court, he said this, so therefore it's true, it's hearsay and not admissible, except for the 17 exceptions. Just in case the lawyers are out there listening, there are 17 exceptions to that, in which one of this might fall. But if they're arguing that they couldn't have relied on that and they wouldn't have brought a case based on that, but if since then they have actually found solid evidence and it was within that limiting statute in terms of when they found it within the known or should have known category. It's whether they say you should have known back then or you shouldn't have known back then, that kind of thing. That I think that's going to be the primary crux of it.
Yeah, and this is where I think it gets so very, very difficult for Massa to be able to establish that, why we bring in this now. If they're saying, well, on the back of Eccleston having done that, we've actually got evidence, and here, for example, are emails from within the FIA or from the stewards showing that they knew of this at the time and didn't do anything about it, that would be an entirely different matter. But if this is solely built just on that interview, and who knows, perhaps they've dug up a witness who's willing to say something as well. But again, you're taking that, have you got contemporaneous evidence to back that up? Or are we, again, just someone saying 15 years later, oh, yeah, well, I was there and I knew that this was said and blah, blah, blah. If you've not got anything like that, I'm amazed, to be frank, that the litigation's even got this far, because it would be so expensive. And that's just it. I mean, certainly, I would hope that Felipe Massa isn't putting his own money into this, because it will have cost an awful lot just to get this far, to get it in front of a judge. And I can't imagine a judge, based on the evidence that is in the public realm so far and the reporting that we're seeing on this, I just don't see the evidence that's there to say why you would have a convincing argument to disapply limitation in any way. It's very, very weak and seems to have prospects of success that we aren't looking. They usually say of prospects of success, can you prove that you've got a more than 51% chance of success? Because when we're looking at a civil case, it's balance of probabilities, which means not beyond reasonable doubt, you're sure that it was the case. It's the balance of probabilities. It's that sort of 50%. So even if you're 51%, probably did happen, that's enough as far as the court's concerned. But if you can't say that that's where you are, then you're not going to have any prospect of success. And I'm struggling to see anything more. I'm struggling to see 1 or 2% worth of evidence here, let alone 51%. And that's where I'm sort of thinking, well, either where's the money coming from to fund this? As I say, it's not. I really hope it's not Felipe Massa. If you've got lawyers doing it, I can't imagine them doing it on any form of contingency or conditional fee, no win, no fee basis. The basis of which those sorts of agreements, I hasten to add, for our audience around the world here, is that you very rarely get those sorts of agreements in the UK anyway, because they're very tightly regulated, and also, if you are going to do that, you're going to want to think, well, we're going to win. And again, I can't see the circumstances saying that, yes, you would win on that.
One of my favorite original theories about this, before Eccleston has firmly set himself down on the side of the FIA here, was that actually it was just Eccleston wanting to make Liberty look bad because he was peeved over the way his departure from the sport went. But it's not an unknown thing for people with deep pockets to fund lawsuits in hopes of payouts. And it wouldn't surprise me at all if there were people out there who felt ill-treated, who would think it would be a good use of money, of which they have more of than sense, to fund something like that, just to make a spectacle and make the sport look bad. Because I can think of certain Russian oligarchs who've not been allowed to participate, who might have a grudge and have more than enough money, just pocket change for them to do this sort of thing.
I was thinking the exact same thing, but then again, I can be a conspiracy theorist. But yeah, well,
plausible, possible is not the same as reality. So is it plausible? Yes. Are we saying this is actually what's going on? No, of course not. But it is an avenue by which financing might have occurred.
Amelia, I think, wants to.
Yeah, so as someone that does not watch motorsports, right, can you just explain? I know, sorry. Why this makes a difference? Could he have, outside of this crash, gained that 1 point and perhaps won the championship? But how do we know that this might have happened and this might have changed the result? Because there's someone that doesn't watch it. Like, what does this mean?
In legal terms, this is called the but for.
So he's trying to argue that if you take the results of this race out of that year's World Championship,
but for,
then the points that Lewis Hamilton won in that race, he's saying, well, that race should have been null and void. Lewis Hamilton wouldn't have had the points from that, which mean that the overall World Championship table at the end of the year suddenly means that rather than Lewis Hamilton being 1 point ahead, he's actually a few points back. And then, ta-da, Felipe Massa is world champion. But what he's searching for here isn't to basically say, oh, yes, I'd now be the 2008 world champion. The basis of his claim, and it being multi-million pound, is to say, well, I should have been the world champion in 2008. And this is how my career would then have panned out. As it was, Felipe Massa spent a very, very long time. It felt like a lifetime he was at Ferrari. And then he left there and had a few years at Williams before then retiring. But he's saying, well, actually, no, my career would have been exponentially. I'd have been paid more and I'd have had more commercial opportunities. And then I would have been probably a pundit on different networks, being paid far more than I am able to currently command as Felipe Massa, runner-up in one of the closest ever world championships in history. Mm-hmm. But, I mean, the main thing at issue in this hearing in London has been limitation. And even then, it's basically saying, can we please even perhaps have a mini trial on the sole issue of limitation? That's 6 years. But even if you got that, even if we get limitation out of the way and the court says, yeah, we'll allow this claim,
you got to get the
I think the arithmetic to calculate it in the way that they have and say, oh, this is a multi-million pound claim worth this, is in of itself fatally flawed. And that's because the thing that affected Felipe Massa's career at the World Championship, it's the accident that the poor man had in 2009.
Yeah. So there's that. There's the limitation argument. I think you could easily find people who would testify, and I think it would be correct. You can look at the telemetry and say, oh, geez, this is kind of suspicious. And boy, it sure did work out for Fernando also very, very well in that one race. But without Piquet Jr. willing to come forward and admit it, what kind of an investigation are you going to have? What kind of a penalty could you have brought if everyone involved stonewalls? You could say we have suspicious telemetry and no other proof. And you're going to get nothing. But here is the thing that I think everybody in this argument is ignoring. And here's the reason why I think I'm surprised. I haven't seen this defense brought up by anyone, but I went and did some looking into cheating in Formula One, and it turns out a lot of people did a lot of cheating. But you know what? I have never found in all of the accounts of cheating that I've read, and this includes teams thrown out, drivers thrown out, entire seasons worth of results erased. I have never once seen an individual race that finished had all of the results for every driver ruled null and void because one person cheated. Period. Exactly. End of. And there is no argument that if they had been found guilty at the time, they would have been disqualified. Renault probably for the whole season. Maybe the drivers, maybe not. But if we assume the worst and disqualify all the drivers, and then, because it's optional under the FIA statutes of 2008, which I did go back and look at, they could choose to move everyone up a step in the results. And I calculated those points, and Lewis still won. In fact, the point I'm making here is the only way he wins the championship. Because, like, if you kick Alonso out of that race because of the cheating, Lewis gets 2 extra points. He wins by 3 points instead of 1. The only way Massa is champion is if the race at Singapore never happened. And on the history of Formula One, as far as I've been, motivated enough to go look, that has never, ever happened as a result of someone cheating in a race. Ever, period. The only time that happens is when the weather is so bad you can't finish the race, or when there's an accident so bad you can't finish the race. And even then, partial points are handed out.
Exactly.
But will the court know that? And will the court rule that way? Depends on when what side of the bed the judge gets up on. Yes, Amelia.
To round this off then, can I just go through Heather, Peter, Matt? Do you think, in your own personal opinion, this case will move forward, or whether it will just go, nope, you had your chance, you missed it. No, we're not going forward with this.
Who you got to tell us who's going first? So,
Heather, why don't you go first, followed by Peter, then Matt. There we go.
I was hoping you go the other way around.
They're going from most informed to least informed opinion. That's what they're doing.
I will say that if it gets past the SOL, which I think that they don't need a hearing on that if they think there's no chance. So there is a chance that it'll get through. I'm going to call it the SOL because I like it that way. If it get through is on the SOL, I still think it will probably just drag on for a while and then settle. I don't know that it would be thrown out. I am, as both Matt and Peter know, I am very into, there's a lot going on in the background that we don't see. We only see what's happening in the courts and in pleadings and in newspapers. In the background, it's like a swan, looks calm on the top. There's a lot swimming underneath. So there's something behind this, I think, that may happen if they get through the SOL.
So my view is that it's not going to get past limitation. Either the outcome of the hearing that's taken place this week will be there's no case here. The judge says, nope, I'm not willing to disapply limitation. I think that will be the most likely outcome. If he doesn't do that, I think he would turn around and say, well, we'll have a preliminary issue trial solely on the issue of limitation, and everyone has to then all come back. And then this whole issue is, give me the evidence that suggests why I should not apply limitation in this case. And that could take weeks. I've seen limitation trials, and I've taken part in limitation trials that lasted weeks. Not the most interesting way to spend your time, but even then, you're only going to be on even you get to the end of that, and the judge is going to say, I will allow the claim, and we then move on, as Heather was just saying. So I think we'd have to go through all of that and the time, expense, and frustration of that before you'd then potentially get to a hearing. And I think the most likely thing that happens is the judge strikes out anyway on limitation. If you get to a trial on limitation, I think the judge would definitely say, there simply isn't enough here. I can't stand up enough here to make a coherent argument in terms of why this should go to a full hearing. So that's how I see this going. And even if, hypothetically, we get to what Heather was just saying there, I think then where it would fall down is that, well, what are you actually claiming for here? Because I don't think you can stack up the value of the claim. So yeah, and this is why it comes back to, I just cannot see the prospects of success. And I don't understand why we've got KCs standing up in the High Court in London discussing this. Where are they getting the money from? And if it is Felipe Massa's poor deep pockets, well, the poor man, because he's not going to get anything from this.
Maybe it was that head injury from the bolt. Sorry.
And that's another thing. I really feel for Felipe Massa. Yeah, he went through that 2008 championship. He then came back from a horrific injury. He should have won races and gave them up for his team. Let's not forget that. Mm-hmm. And arguably, yeah, he would have had, were it not for that accident, his career, I think, would have been very, very different. And I think everyone's always felt that he handled 2008 with a lot of dignity. And unfortunately, I think this is sort of harming that legacy a little bit. But as you say, who's putting them up to this?
Well, as someone who knows almost nothing about UK law, but loves to have an opinion that sounds authoritative, I'm going to go for the following. I find the odds, the probability that this goes even to the limitation hearing exceedingly small, because as far as the public evidence that's been revealed so far, I mean, there's been a lot of people saying stuff, and as far as the evidence goes that's been revealed that actually potentially qualifies it, it's down to Bernie Ecclestone saying something on TV. Bernie is known to be an unreliable witness. He's known to say provocative things that aren't necessarily true. And he has disavowed the meaning of what is being used as evidence. So in essence, if I was a judge, I would say, please take this oath. When you are reported as saying these words, are those the words you said? And if you said those words, what did you mean by them? At which point he would say, no, those aren't exactly the words I said. And what I meant by them was not at all what Massa is saying they mean. And that, there you go. Your whole case turns into vapor. But
Yeah.
more to the point, what he's asking for, and this, I think if I was a judge, this is what I would look at. What he's asking for is to essentially be granted the equivalent of having won the World Drivers' Championship. And there is no regime, even if they'd found it and investigated and come to a conclusion, there is no historical precedent or support, or even in the statutes themselves. When you go and look through the penalties in the International Sporting Code, nowhere does it say if someone cheats, you should throw out the results of the whole race. And that is the one unique way he can claim to have lost the benefits of having been the world champion and therefore had a different career arc to which he's entitled monetary damages for. However, I wouldn't be surprised if at the end of this all, it does sort of go away. But I feel like there's a settlement. I feel like this is the kind of thing that often happens in order to get something settled between Massa and the sport. And the sport has refused, so we find ourselves at the point where you try to bring maximum leverage, but having served on civil juries, not served on, but been, invited in for jury selection, oftentimes what happens is they pick a jury.
Yeah.
And then there's a settlement between the two parties. So I wouldn't surprise me when you talk about stuff in the background. It's a lot of money to spend, but clearly I think there's an invisible elephant in this particular room.
And you remember this was on the Mr. Apex podcast. I predicted in the Cadillac case. I said this is all about a background fight. There's big boys in the back room fighting about something, and ultimately Cadillac will get in, but there'll be some sort of face saving thing that'll happen. They're pushing for something, and Cadillac is in, and
Michael Andretti
Andretti isn't. That was the face saving thing. So Cadillac is in, Michael Andretti is out. I may be a conspiracy theorist, but most of the time it is a conspiracy.
Yeah. And that's actually a really good point you made there, Matt, that if your star witness, your star bit of evidence is the testimony of Bernard Charles Eccleston, who has been found in previous court judgments not to be a reliable witness, it shows that the foundations of your claim really are built on sand.
Does anyone else have anything to add before I bring this episode to a close? Any final closing comments? No. Okay, so that was... Go on, Peter.
Well, I was actually just going to say that it's been great having Matt with us, and I was just going to say, Matt, just for our listeners, do you want to just briefly mention Missed Apex and where people can find you online if they want to hear more from you?
Yeah. So on the socials, I'm at MattPT55, and you can just sort of find me there, or Matt at missedapex.net, org, something like that. But Missed Apex is a Formula One podcast, been around since 2016. We are probably the largest fully independently owned Formula One podcast. We make the Apple charts, and we have a pretty big UK US audience that listens to us. And I just say Acast. You can find us on Acast or Spotify or your podcatcher of choice. And we do we just talk about the F1 races, and we talk about the news, and we try to make it enjoyable and inclusive and non-gatekeepy as possible. Non-gatekeepy. not even as possible, because we were all brand new listeners and watchers of Formula One at one time. And so, yeah, give us a listen. We have a new MotoGP show. Give that a listen. I'm on that too, with some other Mr. Apex people. And yeah, just say hi.
Can I just say my favorite tagline for Mr. Apex is, "We may not always be right, but we're first," or something along those lines.
That's it.
We might be wrong, but we're
We
first.
might be wrong, but we're first. That's it. I knew I was paraphrasing. We may be wrong, but we're first.
Yeah, we don't take ourselves too seriously, even though we try to be very accurate with what we actually say.
Yeah.
And indeed, that's where I should add a disclaimer to this episode, in that we've been talking based on reporting that's out there in the public domain, and everything expressed is just an opinion based on
not legal
publicly
advice,
available records. It is not
yeah.
legal advice, and no warranty is being given or should be assumed.
We assume no liability.
We do not.
There we go. So if you do have any questions about anything that we have talked about today, please feel free to email us at admin@digitallawuk.com. A summary of today's stories are available on our website, as well as the links to the original stories containing more information about our discussions. And if you'd like to hear more from us, including information about subscriber-only podcasts, webinars, and events, then please subscribe to Premium via our Patreon channel using the link in our show notes. A big thank you again for Heather from Anson Evaluate and Matt from Mr. Apex for joining us. And as well, a big thank you to Anson Evaluate for helping to produce this podcast. And if you'd be interested to hear more about Anson Evaluate services, please take a look at their website that you can find at www.ansonevaluate.com, or take a look at their cybersecurity Substack, including information on how to mitigate risks in relation to cybersecurity and regular updates and useful guidance on cybersecurity best practice. Just a reminder that these episodes are available on our website, YouTube channel, podcast channels such as Spotify, Apple Music, Amazon, and essentially anywhere you find your podcasts. Thank you for listening, and we hope to see you again soon.